All right, let's dive right into one of the most powerful and frankly unique articles in the entire Indian Constitution, Article 17. Now, this isn't some dusty, old legal provision. Not at all. It's a promise of a social revolution written right into the DNA of the country. And today, we're going to unpack exactly how it works.
And to really get why this article was so critical, we have to start with the words of its main architect, Dr. B.R. Ambedkar. You see, this quote just gets right to the heart of the matter. What good is political freedom if you don't have social freedom? It's basically meaningless. And that core belief is precisely why Article 17 had to be in the Constitution.
So here's the game plan for today. We're going to break this all down. We'll look at what the article actually says, check out its unique legal powers, look at the laws that give it its teeth, and then dive into some of the key court battles that have really defined its power over the years.
Okay, so here's the text itself. It's short, it's direct, and man, is it potent. I want you to notice three things here. First, it doesn't just regulate untouchability, it abolishes it. Gone. Second, it forbids its practice in any form. That's huge. It leaves zero room for loopholes. And third, it makes it a criminal offense. This moves it from just being a social problem to a crime you can be punished for.
So we've got the text, but what makes it so revolutionary, in the grand scheme of constitutional law? Well, you could say Article 17 has two constitutional superpowers that make it stand out from almost every other fundamental right.
Now this is where it gets really interesting. Most of your fundamental rights are what we call vertical. They're like a shield that protects you, the citizen, from the power of the state. But Article 17, it's horizontal. It works between private citizens. That means you have a constitutional right not to be discriminated against this way by your neighbor, by a shopkeeper, or by anyone else. That is a massive, massive game changer.
And that brings us to its two superpowers, together. First, as we just saw, it's horizontal. But second, it's absolute. You know how rights like freedom of speech can have reasonable restrictions? Well, Article 17 has none. Zero. There's no such thing as an acceptable level of untouchability. It is banned, full stop. And that makes it one of the most powerful, uncompromising rights in the entire Constitution.
Okay, so this leads to a pretty big question, one you're probably thinking about right now. The Constitution uses this really charged word, untouchability, but what does it actually mean? What's the legal definition? And the answer is, there isn't one. And get this, that was completely intentional. The framers of the Constitution were brilliant. They chose not to define it because they were afraid a narrow, rigid definition could be used to find loopholes. By leaving it open, they gave the power to the courts to interpret it broadly, letting the law adapt and fight this practice in all of its ugly, ever-changing forms. So the Constitution gives us the ban, but that's just the starting line. It's up to Parliament, using its power under Article 35, to actually create the laws to enforce it. So let's take a look at the toolkit they built to give Article 17 some real-world bite. Now, this legal framework didn't just pop up overnight. It grew, it evolved. It all started back in 1955 with a pretty basic law. Then, in '76, they beefed it up. But the real game changer was in 1989 with the Atrocities Act. That was a much, much tougher law, and it's even been strengthened as recently as 2018. And if we put the two main laws side by side, you can really see how things ramped up. The 1955 Act was focused on those classic forms of discrimination, being denied access to a temple or a well. But the 1989 Atrocities Act, it went way further. It brought in harsher punishments, special courts to speed up trials, and it covered a whole spectrum of humiliating and violent acts. Okay, so let's open all the case files, because a law is just words on paper until it's tested in a real courtroom, right? Let's see how the Supreme Court has actually used these laws. Let's kick things off with a foundational case from 1993. The situation was this. A group of people from a scheduled caste community were stopped from drawing water from a village well. The case made its way all the way to the Supreme Court. The question was simple. Is that untouchability? And the court's answer was a huge, emphatic yes. The judgment literally called it a classic form of the practice and sent a super clear message. These laws have to be enforced strictly. This was a massive win for the spirit of Article 17. All right, next up, we have a case that really pushed the boundaries of Article 17 even further. It's 1982, during the construction for the Asian Games. A case was filed arguing that workers, including many from SC/ST communities, were being exploited. Could that kind of exploitation be tied to Article 17? Once again, the answer was yes.
And the key takeaway from this one is the idea of an affirmative duty. What does that mean? It means the state can't just be a passive bystander. It has to actively step in and protect its citizens from this stuff, even if the ones doing it are private companies or individuals.
Now let's fast forward to a much more recent and way more contentious legal battle. In 2018, the Supreme Court looked at the Atrocities Act, specifically its tough provisions for immediate arrest. The debate became, was this powerful law being misused, and did it need some new safeguards?
And in a hugely controversial decision, the Supreme Court diluted the act. It basically said that police could conduct a preliminary inquiry before making an arrest. Now, this was seen by many as taking a lot of the immediate power, the real teeth, out of the law.
But the story doesn't end there. Not even close. In this incredible showdown, Parliament acted almost immediately. They passed an amendment that completely reversed the Supreme Court's judgment, putting the original tough provisions right back into the Atrocities Act. This whole back and forth just goes to show you how vital and how contested this legal ground still is.
So, as we wrap things up, I want you to just remember this one thing. In a constitution that is filled with checks and balances and reasonable restrictions, Article 17 stands almost completely alone. It is an absolute, uncompromising statement on human dignity.
And that leaves us with a final, really challenging question. The Constitution abolished this practice over 70 years ago, but these fierce legal battles to keep the enforcement strong, they prove the fight is far from over. So we have to ask ourselves, if a constitutional promise, this absolute, still needs such a constant, fierce defense, what does that tell us about the gap between the law we write on paper and the justice people experience on the ground?